All right. Good morning, St. Louis. Welcome to our webinar this morning about intellectual property strategies for executives and entrepreneurs. Happy Veterans Day. Special shout out to our friends in uniform. And it's unfortunate that we can't be there in person, but hopefully next year we'll be able to meet you live. In the meantime, if anyone has any recommendations as to whether we should hit Pappy's Smokehouse or Salt and Smoke or Bogart's, let us know. We'd love to hear your comments about that. Anyways, let's move to the next slide, please. Thank you. So a couple of housekeeping details. Our presentation this morning will be recorded and we'll send a link out to everyone after the presentation so you can review it later on. If you have any questions, feel free to type them into the Q&A box during the presentation and we'll try to get to them real time, or if not, we'll try to address them at the end of the presentation. And don't forget to check us out at slwip.com for other webinars and IP related information, as well as social media, LinkedIn, Facebook, and other platforms. Next slide, please. A couple of quick introductions. I'm your host, Doug Portnow, and I'm a registered patent attorney at the law firm Schwegman, Lundberg, and Woosner. And I'm based out of our San Jose, California office in Silicon Valley. And I primarily focus on medical devices and mechanical and electromechanical inventions. And my background is in mechanical engineering. And if we could have the next slide. My colleague, Leah Westman, is also a registered patent attorney, and she focuses on Chem Biotech inventions. And our third panelist, next slide, is Lynn Nguyen, who is our EE software expert and has her degrees in engineering from our friends up in Canada over at McGill University. And I just love to say that. Next slide, please. Today we're gonna we have a very diverse audience today. We've got a lot of people registered in different areas who may be involved in chemistry, biotech, EE, software, mechanical, all kinds of different technologies. So what we wanted to try to do was provide just sort of a general overview of key IP issues that executives and entrepreneurs may experience when dealing with their inventions. So today we're going to talk about what is IP, the different forms of IP. We're going to talk about how you demonstrate or how you prove ownership of intellectual property. We'll talk about the very important concept of freedom to operate, meaning related to patent infringement. We'll talk about patentability, meaning what type of claims you can get in your patents, what type of protection you can get. We'll talk about portfolio management, cost control. If you're going through fundraising or an exit event, we'll talk about IP due diligence that occurs during those processes. And we'll talk very briefly, we'll introduce the concepts of patent valuation, where you actually try to associate a dollar figure to your patents. And we'll just briefly touch on some newer tools that are becoming available to practitioners using analytic techniques. If we could go to the next slide, that would be great. So with that, I'm going to turn this over to Lynn, who's going to talk to us about the 4 types of IP.
So just kicking it off, different types of IP. We have trademarks and copyrights, which are often referred to as soft IP. And then we have trade secrets and patents. Next slide, please. So trademarks. Trademark, actually, or service marks, is a word, phrase, symbol, and or design that identifies and distinguishes sources of goods or services of one party from those of others. Looking at these examples, you have McDonald's golden arches with the words, you have Colonel Sanders and KFC. So when we see these marks on our burgers or buckets of chicken, the marks let us know as consumers what company is the source of the product. Trademarks can also be given to colors. Colors can be like, examples are Tiffany blue, UPS brown, Home Depot orange, John Deere green. Really just stating these colors, it feels like it triggers all of the, you can actually see their logos in your mind. So, but again, don't confuse the term trademark with ownership of the color. Trademarking a color just simply allows that company to use a particular combination and shade of color in its own industry. Examples of trademarks can also be given to sounds. So I looked up sounds that were trademarked because it's been a while, and it really reminded me that a lot of these sounds that are trademarked were reminiscent of a time that we were all able to go to the movie theaters in person, because you'll have things like the MGM Lions roar, the 20th Century Fox fanfare, Lucasfilm's THX Deep Note. I actually forgot what that was, and I have it here for you in case anyone forgotten it.
Definitely not that.
Yeah, that's it. That's the THX sound.
Oh, really? Okay.
Yeah. And the first ever sound that was trademarked in 1950 is the NBC chimes. It's funny because now we don't really have a lot of commercials, so I feel like I kind of forgot it, but it's this.
Television.
Okay. So fun facts. Other trademarks that can be given to, you can also be given to smells. So a trademark smell, the classic example that we learned in school was the embroidery thread that smells like plumeria flowers would tell people who made that thread. But looking up more recent smells that were trademarked, we have Verizon wireless stores in 2014. They actually trademarked the flowery musk scent of their stores. Verizon plans to pump this trademark scent into their larger, more marquee retail stores, and it's funny, their application argued that the smell would help them distinguish these locations from other communication or consumer electronic retailers in an increasingly crowded field. So we have that to look forward to, flowery musk scents of Verizon wireless stores. Next slide, please. Copyrights. A copyright protects original works of authorship for an expression fixed in a tangible medium. That includes literary, dramatic, musical, artistic works, which are poetry, novels, movies, songs, computer software, architecture, all these things. But a question that comes up a lot is, can you copyright a dance move? Yes or no? And it's actually complicated. The dancers and choreographers can copyright moves as long as they're fixed in a tangible medium of expression, meaning that they have to be publicly known in a video or movie. So in 2018, a lawsuit against Epic Games and Fortnite was filed, and that was for stealing and selling dance moves in a video game. So the plaintiffs include Alfonso Ribeiro, aka Carlton from Fresh Prince, the Backpack Kid for doing the floss, and rapper 2 Milli for Milli Rock Dance. And the question is really whether their moves are fully formed enough to constitute intellectual property. And that's because the short sequence of moves may not be enough for a copyright. It'll be interesting to see how this case turns out, but currently it's on pause. So we'll see. Next slide, please. Trade secret. Trade secrets is anything that you can keep a secret, and as long as it lasts as long as you can keep it a secret. So examples of this are manufacturing processes, client lists, and formulas. For instance, the Coca-Cola recipe for the signature drink is a trade secret. KFC's secret blend of 11 herbs and spices is a trade secret. Google's secret search algorithm, I guess it's secret algorithm too. McDonald's Big Mac special sauce is also a trade secret. What are the pros and cons of trade secrets versus patents? First, there's no time limit on the amount of time that a trade secret can be protected, whereas for patents, you have 20 years for utility patent and 15 for a design patent. Public disclosure, if in patents, we disclose our invention in exchange for a 20-year patent term or 15 for design. And enforceability, that goes hand in hand with the public disclosure. If someone else is using your invention, then you can actually enforce your patent, but you can't do that with a trade secret. Next slide, please. All right, and finally, we have patents. The different types of patents include utility patents, which can be for machine processes, machine process, article manufacture, composition of matter, and this is actually the most common type of patents that we work with. Design patents are for ornamental designs. That includes, an example is rounded corners on your iPhone. That is a design patent. The jury found that Samsung infringed on this design patent and awarded more than $1 billion to Apple. But recently that was reduced down by the Supreme Court. Finally, we also have plant patents, and I have to say I've never done a plant patent before. This is for plant varieties that are asexually reproduced, and I found out that a certain plant patents include the Hass avocados, and in 2019 we now have the first ever hemp plant patent to be awarded, and it's a hemp plant named CW2A. So that's stuff to look forward to. And in other countries outside of the US, Canada, and the UK, they also have utility models. And that's sometimes referred to as a small patent. It's easier, it's cheaper to obtain, but then you get a shorter term. And it's not something that comes up a lot in our practice. But today we're gonna focus on patents, and I'm gonna pass it over to Leah to tell us more.
Thanks, Lynn. Well, hello, everyone. We're glad you could join us. Like Lynn and Doug mentioned, we'll be focusing most of our discussion today on patents because that's a lot of what the three of us do in our practice. And we're hoping we can give you some useful tips regarding patents in general. So Lynn gave us a great overview of patents. And if we could go to the next slide, we'll jump into a little bit more of what is a patent. And some of you may already know plenty of this, but a patent itself, it's actually what we call a negative right. So that means that it's not a license to do something or make something. A patent, instead, it gives the person who owns it the right to stop someone else from making, using, or selling the patented invention. And just a reminder is that depending on what area you're in, there may also be other regulatory approvals or clearances that you'll need before you can manufacture and sell your own product. So particularly in pharmaceuticals, biotech, medical devices, for instance, you may be dealing with the FDA or other agencies. Now, like we just discussed, a patent itself, it gives the patentee the right to exclude others from making, using, or selling the invention, which means that if you're holding a patent on your invention and your product that you're making, you potentially have an ability to halt or stop a competitor from doing the exact same thing, which can be quite useful. So if we'll go to the next slide, that leads us into our discussion of, why would you obtain a patent? So the patent process can be extensive and it can be long, but at the end of the day, when you're working with a technology company and a startup, a lot of companies, when you're beginning, your idea, your invention, that's all you have, right? That is what you're basing your company on. And patents are an important tool because they'll provide proof, for instance, to potential investors that you have an invention or a potential future commercial product worth investing in and protecting. And particularly early stage companies, patents can often be the only property you own because at that point you may not have sales or clinical data or other tangible things in your portfolio. And patents as a whole will help you protect your own invention, your own technology, by excluding competitors from doing the exact same thing. And essentially in that way, patents are a property that can be monetized. They can help with your company valuation. We'll talk later today about maybe how you could potentially value some of that portfolio. And, as a whole, having a patent or a patent portfolio can be proof to other people and other companies that your company has something worth pursuing. So that kind of begs the question, how do you get a patent? As I mentioned, it can be an involved process. So in order to get a patent, you would file with, in the United States, the patent office here, or equivalently in a foreign jurisdiction. And in the US, the barrier is that the invention has to be novel, meaning it has to be new. No one has done the exact same thing before. It has to be what we call non-obvious, meaning it can't be an obvious variation of something that's been done before, or in other words, it has to be inventive. And it also has to be what we call enabled, meaning the patent application itself, as it's written, has to have enough information to let someone understand what the invention is. So generally, the bargain that you're making with the patent office is you will provide enough detail about this invention in your patent application in exchange for what we call a limited monopoly. So patents as they're issued in the US now have a term of 20 years if they're issued, and that means you could exclude someone from making, using, or selling the invention for that 20-year term in exchange for fully describing in the patent application the details of the invention, so someone else who's familiar with that area of technology could pick it up and replicate it if they needed to after that monopoly has expired, or build off of it.
Can I just jump in real quickly?
Go ahead, Doug.
Question I think that is perfect for you where you are in your talk right now, and it's really it's asking about the trade-off between public disclosure and keeping things sort of under the radar screen. I don't know if you can see that, or let me read that question off for the audience.
Why don't you read aloud?
Okay, so the question is, I'm in the middle of 2 patent applications right now. My patent attorneys have asked for actual formulations. I have provided them, but feel a little nervous. If the patent application fails, I feel like I've told my competitor what I consider my IP. So that's part 1, and then we'll turn to part 2 of that question. Can you talk a little bit about that balance between disclosure?
Yeah, I'm happy to, Doug. So you have to, like we said earlier, enable the patent is the phrase we'll use. It means you have to have enough detail in the disclosure of the patent so that if someone else in the field picked it up, they would understand it. So for example, in a chemical area, if a chemist picked up a patent application, they have to be able to, based on what you're discussing in there, understand what the invention is for it to be fully enabled. And that's part of the bargain we make with the patent office here. So patents are a constitutionally granted right. They're in the original Constitution of the United States, surprisingly. And the idea is to drive innovation forward with patents. And we do that by making this bargain with the government and saying, you'll apply for a patent with the government and they will give you a limited monopoly, but only if you come forward with all of what you've invented. And that helps drive innovation forward because competitors looking at your patent will have to design around it, which means they'll have to creatively work around it, build other solutions in the technology area. And it means that later on, when the patent monopoly expires, that people can build off of that invention, right? So previous mechanical inventions of years and years ago are the foundational blocks for current mechanical inventions. So that's kind of the high level bargain of why we have people disclose detail in patent applications. I'd say for this particular scenario we're being asked about, where you're worried about the competitors seeing your IP, well, at the end of the day, you're not going to get any protection if you don't provide that detail because of the bargain with the US government. But moreover, because we have these standards where when anyone files a patent, it has to be novel and non-obvious, it means that if you do file an application with the patent office, most applications filed with the patent office get published 18 months after they're filed. And so that information is out there, but it means that no one else can file on it either necessarily. So they wouldn't be able to, your competitor wouldn't be able to see what you filed, copy it exactly, and file a patent on it because that wouldn't be novel. Doug, do you have further thoughts on this discussion here?
No, I think that covered it. I mean, again, to our audience, the bargain is, I scratch your back, you scratch my back. And that is with Uncle Sam, the government. If you give them information about your invention, you potentially can get a patent. And that means you have to disclose that information. And that helps advance the body of knowledge out in the public domain. But if you don't get a patent, then you haven't really lost anything because there's nothing there to protect to begin with. So I'm not sure I see the concern. And part 2 of that question deals with obviousness. Do you want to take that now or later on?
Well, so it sounds like the second part of the question says, my patent application has been described as novel but obvious. We are challenging the obviousness. What we have has never been done before. So, without looking at the case itself, I can't tell you whether that's a fair analysis or not, but what I can say is that there are two different concepts, novelty and obviousness. So novelty means that it is brand new. This exact thing hasn't been done ever by anyone. And you can't find something that shows the exact same invention, right? That's different than an obviousness issue, where the term that's used kind of internationally to describe this is inventiveness, which sometimes can be a little clearer in my mind, meaning that for something to be non-obvious, it has to be inventive. It has to kind of be above that threshold of just a minor change or an obvious change. And sometimes that bar is just harder to prove and harder to show. And honestly, it's not unusual to go back and forth with the patent office a number of times to explain to them and work with them, showing whether the invention is non-obvious, right? So the process can be very ongoing, and that discussion sometimes takes some time, and it very much depends on the particulars of the situation, whether you're going to be arguing about novelty or obviousness or both with the patent office. So hopefully that answers your question. I think let's continue to the next slide real quick here. So shifting gears a little bit, we've talked about what patents are, why they might be useful or valuable, and a little bit about how you obtain one. At the end of the day, if you don't own the patent portfolio itself, the rest of this discussion is not useful, right? So under US law, the person who owns a patent when you file for it is the inventor of the patent itself, which means that when you have a company that's employing engineers or scientists, you need to have the engineers or scientists, the inventors, you need to have them assign the rights of the patent to your company. So like any other type of property, you want to own this. So similar to real property, where you could shift ownership in a house or piece of land to another party, similarly in IP, you want to assign the ownership of your patents, trademarks, copyrights to the company that actually is paying for the research and owning them. This has to be recorded at the patent office. And so general practices is that you should include language about the ownership of not just this particular patent application itself, but also any patents that may be in what we call the family of patents. So often you have a series of patents that are related to each other that have similar concepts or inventors, and you want to make sure the assignment documents you're using cover not just this particular filing, but related ones as well. And at the end of the day, you want to be able to demonstrate ownership of your own IP so that you have the ability to license that or to sell that or leverage that IP. Now, at the end of the day, if you don't or can't demonstrate ownership of your IP, then it opens you up to a liability for patent infringement. And as we know, investors like to avoid risk, so shoring up ownership and assignment is really important. We could go to the next slide. So a couple things to remember as we're talking about assignments is obtain assignments, promptly from your inventors. People change jobs, it happens, and it's hard to track down people and get assignments signed once they've left. Similarly, record your assignments promptly with the patent office so that you don't have any issues down the road. It's useful to audit your portfolio and make sure there aren't any issues in ownership to keep track of these things. And you want to double check there aren't any typos, right? You want to check that the name of the company that is the assignee is correct. You want to ensure the names of the inventors, the assignors are correct. You want to check the numbering, the serial numbers that are directed to the patent applications, and all these kinds of checking all these kinds of things in audits can help later on if you are in a due diligence phase, which Doug will talk about later. Now, additionally, you do want some sort of backup. So when you have employment agreements or consulting agreements with employees or contractors, it's good to have language in there that addresses this issue as well, just as a safety net. So with that, we will shift gears a little bit from the ownership aspect of patents to what sort of patents can I get? And I'll hand it back to my colleague Lynn for that.
Thanks, Leah. So patentability is what kind of claims can I get? Claims outline the metes and bounds of your patent application. It's the section that we will argue the most about with the USPTO. So just looking at the slide, to say you want to write claims that are broad enough to block as much as you can, but you don't want to claim you're something so broad that they are invulnerable, that they're vulnerable to invalidity attacks. But on the other hand, you don't want your claims so narrow that they're invulnerable to invalidity attacks, but also cover your commercial embodiment, nothing else. So you really need something in the middle. I guess I'm gonna give an example. So in social media companies like Snapchat, we have inventions that generate filters based on geolocation. So for example, if you happen to be at a music festival, like say Coachella, then you'll actually have filters that are unlocked that are Coachella related filters, right? So how do I claim something like that? You don't want your claims to be so broad that you're claiming all camera devices that capture selfies, but you also can't have it be so narrow that you're only getting a patent on filters at Coachella. So you really need something in the middle. An example of that, I guess, would be, what if you have a geolocation within a radius that determines what events are in the area, and then that will determine what filters my user will be able to access. So that's kind of the idea of writing claims. Also, you need to consider writing a range of claims. You can have broad claims, narrow claims. You really want to cover all your bases. Next slide, please. So when we look at our claims, you want to cover your commercial product, target competitor devices, and also design arounds. So how do we do this? We do want to know our prior art. Next slide, please. All right, sorry. So how you want to know your prior art to be able to distinguish your invention from the teachings of that prior art. So how does this help? When you know if you know your prior art, this helps during patent prosecution, because if you know what's out there, you know what you can write or more detail about in order to provide a little bit more backbone to what you're claiming. So as an example, if you need to differentiate avatars from selected icons, then how do I write that in my application? I need to explain that, avatars look like me, they look like human beings, they don't look like any icon that I've selected. This also helps during IP due diligence, because you've actually shown that you have keeping in mind your prior art when you're writing your claims as well as your specification. Finally, you should map your claims to the commercial product or a competitor's product. So if we can actually see what competitors are making and we have a better priority date because we were quick to file our application, then we can also file continuations that are capturing what the competitor is doing. We can target our claims accordingly. What can I patent? What should I patent? You can patent anything made under the sun. But things that you cannot patent are you can't patent laws of nature, naturally occurring things, and abstract ideas. What does that mean? A law of nature, that's pretty straightforward. It's things like photosynthesis. No one can patent that. Abstract ideas can be mathematical algorithms, organizing human activity. That's like, if you're managing personal behavior, relationships, interactions between people, social activities, like you can't patent that either. And finally, mental processes are also abstract ideas. And I'm going to circle back to why that is an issue for us in software. But mental processes is defined as concepts performed in the human mind, including observation, evaluation, judgment, and opinion. What should my patent portfolio cover? We try to cover a wide range of claims. You should include claims like device claims, medical computer method claims, manufacturing claims, system claims. CRM claims are computer readable medium claims, competition claims, and product claims. So those are some examples of claims that we try to draft. Next slide, please. What should I avoid patenting? You should avoid patenting things like if there's no commercial value, then that's probably not worth it. If you don't think you'll ever practice that invention, maybe we can drop that one too. If you don't think your competitor will ever practice it, or if it just doesn't make economic sense. This is really a per company assessment. It's based on your budget and what your goals are. If you have a big patent budget, then yeah, you can cast a really wide net and go for everything. If you have a smaller patent budget, you have to be more selective about your filing strategy, pick the most important innovations for actually your business. Finally, when should I file? US, just like most of the world, is a first to file system. So you get a priority date based on the day that you filed your application. Therefore, the sooner, the better. And you can also file provisional applications if you haven't fully baked your idea yet. So that is, you can file a rough provisional application, work it out, and then within a year, we can convert it to a non-provisional, which is the one that will be processed by the USPTO. I'm going to pass it back to Leah now, and she's going to talk about FTOs.
Actually, if I can just jump in real quick. Lynn, there's a couple of questions, 3 questions that I think fit nicely into your wheelhouse. First one is, somebody is currently building a crowdfunding platform, and the question is, does he or she need to patent or trademark the startup company? Thoughts on that?
Yeah, so I mean, that's a really broad question, right?
Yeah.
If you are crowdfunding it, what do you mean by, if you want to trademark your startup, that means you are trying to maybe trademark the name of your, or the logos that are associated with your company. You can, that's not, the difference between trademark and patent actually is that trademark can also, you can gain those rights, not based on a first to file basis, but you can actually gain those rights based on use as well, but that's a whole other thing. With regards to patenting it, it depends how much you're disclosing. If you want to have a patent, the problem is you don't want to be in a position where you're crowdsourcing, you've shown everyone all your secret sauce, and then someone sees it and then they file it and you don't have a patent because they're the ones with the first to file priority date. So really, I think like a broad question, but you should look into what it is that you're disclosing in your crowdsourcing and decide whether you've disclosed a bit too much, maybe. And if that's the case, you should definitely think about at least filing a provisional application to get your dates down.
Okay. And if I could throw another question at you, Lynn. The question is, can you comment on the pros and cons of algorithm patents? I think you'll have an opinion about that, as opposed to simply copywriting software. This person has been told that algorithm patents are too easy to circumvent and are often not worth doing. And how does this play out with machine learning algorithms where training data is instrumental in how the algorithm works?
Right. So that is basically everything I do. I would recommend definitely filing that algorithm patent. We call them software patents. There are ways to circumvent to make it valuable. Currently, I was going to talk about this a little later, but currently we are facing a lot of 101 challenges. 101 meaning like, is it a patentable subject matter? But the courts and subsequent cases are definitely talking about where it is patentable, even if it is based on software. And it's not necessarily easy to circumvent. I would say that you just have to be upfront about and claim accordingly what it is that your application is doing. And then also make sure that you have practical applications disclosed and how that is an improvement on the prior art. And those are the things that help us move it forward against the 101 rejections. Copywriting software, honestly, like you could, but that's really different too. Like if you're just going to circumvent, people can also circumvent that. You can change, you know, when you write software, there's easy ways to maneuver, you know, your code in order for it to not be covered by that copyright anymore as well. So I believe that an algorithm patent actually would provide you with more coverage, because you're basing it on what it is that it's meaning to achieve.
Okay, good. Couple questions. Maybe Leah, you want to take the next couple of questions. One question is about knowing relevant prior art. The comment is that some practitioners don't seem enthusiastic about knowing prior art. So what would the client be losing under that approach?
All right, Doug, happy to talk about prior art here. So Lynn covered kind of the basics of how you might change your claims based on what you know about the prior art. So first and foremost is you as an inventor, as an applicant for a patent, and the attorney you're working with have a duty to disclose to the patent office any prior art you're aware of that's that's material to the invention. And so you can't, you know, hide it. You have to disclose it, because at the end of the day, the purpose of the patent office is not to stop you from getting a patent. It's to work with you so that the patents that are issued are actually inventive. And that's always done in light of the prior art. So prior art, as many of you know, can be prior patents, patent publications, academic articles, any of a public disclosure of information. And there's a lot of different things that fall under that, as you can imagine. And prior art in the area of your technology is something that predates your application. And so the prior art really should already be informing your work in some ways, because if you're an expert, for instance, in cardiac pacing medical devices, you're probably aware of what the background of technology is in the area you're working in. And it means that what you're inventing and what you're creating is trying to do something different or something new. And because that's generally how you're approaching this patent process, it means that being more aware of what's already been done, it helps you be more inventive, but it also helps you in sculpting the claims in your patent when you finally decide to write this application. So if you have a brilliant new idea, and there are 2 or 3 other pieces of prior art that are similar, it means that you can write your claims a little bit differently, so that they're not overly broad, so you're not running into all these issues. So, I mean, generally, it is prudent to have an idea of what's going on in the technological field you're trying to get a patent in. Specifically with claim drafting, it's very helpful and informative, and you're going to have to look at prior art in this field anyway, because the examiner at the patent office will be doing a search when they examine your patent application. And so you're going to have to deal with it sooner or later, and it's a lot better to upfront deal with it. And at the end of the day, you know, prior art, it's not bad, right? You don't want to disparage it. It just means you have to be creative in working with your attorney in how you're going to define your invention and why it's different than the prior art. So hopefully that answers that question. Lynn or Doug, anything to add there?
Oh, I think that's great. Why don't we just take one more question and then we can move into FTO. Lynn, maybe you or Leah, you want to take this? It's up to you guys. But we have a counselor with a small business development organization that helps teach startups. And the question is, what's the best timing for a startup with low funds to pursue patents? You can spend a lot of time and money on patents when you don't really have your inventions defined or your business model completed. So any comments on the timing on that?
Well, I guess I can jump in here. So, I mean, I think Lynn touched on this earlier as well, which is that, you know, in a perfect world where you have endless resources, you love to file patents on everything, right? And that's just not feasible right? Because it takes time and money, and it takes strategy and innovation. And you know, I think we'll talk a little bit about some of this later on when Doug's discussing, but you want to pick and choose, right? And talk about which things are most commercially valuable to your company or could be commercially valuable, right? So when you're talking about filing cases, provisional patents are a good tool up front, especially when you're still developing the technology, when you have less resources right away, because that gives you a year placeholder in which you could raise more funds, in which you could determine what exactly are going to be your commercial embodiments. And I mean, I do think that kind of the earlier the better, because we are in a first to file system, but it's very dependent on a case by case basis. And it has to be very focused for startups that don't have a lot of resources. Lynn, anything to add there?
I was going to jump in and say, like, I work with a lot of tech startups that are in that position where, you know, they're low funding, they want to get something written down to protect themselves, and then use that in order to generate more funding. The beauty of writing a provisional application is that the minute you write one, you can say you have a patent pending, and VCs love that. So, I mean, depending on, you know, the type of provisional that you wrote, you're also very limited to everything that you disclose in that provisional will benefit from that filing date. So, you know, definitely put in the effort to write something that discloses more or less everything that you intend to capture, or anything that you know at that time frame in that provisional application. I've seen a lot of provisionals, you know, I've seen a lot of provisionals that after you file it, at first you're like, they don't know if they're going to move forward with it. And, you know, a year down the line, it turns into the cornerstone of like what they achieved in their patent portfolio. And we're just pulling out more and more divisionals out of it, continuations out of it. And they build kind of like they end up building around what it is that they wrote in their provisional application and get like a bunch of patents based on it. And that always looks great for more funding. I also wanted to circle back quickly to the question that we had previously about machine learning algorithms and training data. I realized I didn't answer that. For machine learning algorithms, we definitely cover that in our patents. We've had a huge uptick in machine learning and a lot of, what is it called?
AI?
Yeah, like a lot of that. And then, like, you know, all our applications, like we do have to talk about the training data that is used in order to create that machine learning, but also we generate applications that think about, okay, what inputs are being used into that black box? What do you then generate as an output? And honestly, those applications I've seen a lot of allowances on those as well. So definitely yes on patenting your machine learning algorithms.
Okay, great. We're getting some good questions, but why don't we move into FTO and then we can circle back to some questions if we have time.
Sounds good, Doug. So I'll discuss with you guys a little bit about freedom to operate. We refer to this sometimes as clearance analysis or searching, but a freedom to operate analysis is something you would do earlier in your technology development. And it's a process where you work with your attorney to identify key features you're developing in your portfolio and search, you know, the prior art out there, right? So search the patents and publications that may be in and around those areas. And that type of analysis can help you create distinctions, excuse me, between your product and your technology, and then what other parties have been doing. So for instance, what your competitors have been doing. This also can help you potentially avoid some pitfalls, because if you figure out what third parties are doing, you can avoid designing directly into their patent portfolio and try to avoid some potential infringement of their issued patents. And because of the nature of freedom to operate, because you're searching, patents and publications around this technology, you can do preliminary freedom to operate analyses as you're developing your technology, but really you won't be able to conduct a formal analysis until your product design is frozen in place. And because of that, freedom to operate analyses can be kind of like trying to hit a moving target if your technology as it's being developed is constantly changing. But they're also still very useful early on in helping develop your technology strategy and your patent strategy later on, and may come into play later on when you're filing applications on this technology and you're trying to determine the claims that you want to pursue. So freedom to operate analyses actually can also be part of a much larger due diligence analysis sometimes, which I'm going to hand back to Doug to discuss.
Okay, next slide. So we're all entrepreneurs, we're all in startup companies here, I think we can more or less assume today. And what do we need? We need money, we need capital to keep things going, right? So you're probably talking to friends and families, angel investors, maybe you're talking to venture capitalists, maybe you're talking to larger companies. So guess what? You're gonna go through some kind of IP due diligence. If you're dealing with friends and family, they know you, they trust you, the diligence level is probably gonna be fairly minimal. But if you're dealing with, professional money people, they're probably going to want to look a lot closer. And so I just want to talk very briefly about the IP due diligence process. And basically what you want to do is craft a story, a credible story about your intellectual property position that minimizes risk for the investor. So when is diligence conducted? During any kind of fundraising event. It may be a small amount of diligence or a large amount. It could be conducted during an exit event, such as a merger acquisition or an IPO. And like I said, you want to create this credible story. And this is all about risk management for the investors. So if we could go to the next slide. And I'm going to kind of go through these pretty quickly just so we can get caught up a little bit, since we've kind of tried to focus on some of the great questions that are coming in, but we do want to provide a nice overview of some of these other topics. So how do you prepare for IP due diligence? Well, they're going to have a list of questions. So first and foremost, ask them for those questions. That's perfectly fine. That'll give you a chance to review the questions and prepare answers. And if you need help, you can engage, patent counsel to help you deal with these questions. Also, be organized. Make sure you have a master list of all your intellectual property. So a master list of all your patents, if you have any trademarks, and try to categorize any trade secrets that you may have. These days, in the virtual age of data, typically a data room is used where all these documents are uploaded and stored so that any investor can take a look at them whenever they want, and that'll be sort of your proof. Those are the source documents, if you will. As Leah talked about and Lynn talked about, make sure you know your prior art and be ready to provide a list of what you think is the most relevant prior art, and be able to distinguish your invention from the prior art. Be able to tell those investors, hey, I've got this invention and here's some patents or publications that are kind of close, but what we're doing is different because of X, Y, and Z. Again, you want to be able to tell a story that, no, we're not doing the same thing as somebody else. We're doing something different. Other issues that you'll have to address, again, are the FTO issues that Leah just talked about, which is you find those lists of patents that are most relevant and be able to distinguish why you're not infringing on the claims in those patents. Again, because if you're infringing somebody's in patents, do you think anyone's gonna want to invest money in your company? That's a tough sell, right? Because I'm going to give you money and wait, you're going to get in a lawsuit. That's a tough challenge to deal with. So make sure you deal with FTO issues. And then there may be some other issues that some of the things that we see are disgruntled ex-employees who went off and did something which, potentially compromises the company's position, or maybe they filed their own patents which collide with your patents, that sort of thing. Have you received any cease and desists, or what we call nasty grams, from other companies saying you're infringing or offering to license their technology to you? Is there other litigation going on? So, be ready to tell a story about, all of those things. All right, and Michelle, if we could switch to the next slide. You're going to file these patents, and as someone commented earlier in the questions, that filing patents can be a costly exercise. It takes time and money and resources to manage all this stuff. And the analogy that I always like to use is that intellectual property is kind of like having a pet, right? Well, if you have a pet, you gotta give your pet tender loving care. You got to take your pet to the vet. You got to feed your pet. All that kind of stuff. So same thing with intellectual property. It needs attention. Otherwise, A, quality could suffer, or B, you could end up spending a lot of money, more than you want. So those are things that need to be managed. So we do recommend periodic reviews of your patent portfolio or your IP portfolio. And you'll see, I think some things will sort of float to the top, which are more important than others, and things that sort of sink to the bottom might be lower priority, and you can get rid of those and stop. You can just let them die and not have to keep spending money on that. So that's, I think, the value in reviewing this stuff, maybe once or twice a year. So not only will you save cost, but you'll also see where maybe there are deficiencies, where you thought, oh, maybe we should try to get a patent on this invention or this concept, and maybe you want to file additional IP on those things to fill the holes. But things do need to be prioritized. I think Leah mentioned this. You've got to kind of file selectively. You can't just file on everything, because otherwise you'll probably, if you have super deep pockets, then yeah, go for it. And that's patent attorney's dream, is to file lots and lots of patents. But we understand that there's a budget. So prioritize these inventions and figure out what you want to file first, and what can wait or what can be dropped. Another area where we see huge expense is when you pursue foreign protection. So, typically you're going to file in the US, and then within a year, you'll end up filing either PCT or filing directly in a foreign jurisdiction. And then, once you start filing in foreign countries, that's where costs can go up exponentially, because now you're not talking about just one US patent application. You're talking about the US application, maybe the European counterpart, maybe a counterpart in China, maybe a counterpart in, Taiwan, or who knows where. So those costs start going up. So be careful where you file, and select your foreign jurisdictions very carefully. And then with any foreign cases, there are annual annuities. Those are, we'll call them patent taxes, that you have to pay to those foreign governments to keep those applications and patents alive. So again, you got to kind of watch that. And if we could move to the next slide, please. Another key aspect of portfolio management is managing the life of your patent. So try to get maximum patent term adjustments. And if you're dealing with drugs or certain medical devices, you can actually get patent term extensions. Next slide, please. And I'll just mention the next couple things really quickly, because we are running out of time. Patent valuation. So there are generally three models for assigning a monetary value to your IP. One is comps, and that's the same as what you do when you buy a house, right? You look for something similar to your house, and if you can figure out what that house sold, then your house is probably going to be a similar value. So same thing with a patent. If you can find a comp comparable to your patents that was sold, and you can get that information, that's a good benchmark. The second one is what's often referred to as the equivalent R&D cost to develop the technology. So how much did it cost for you to develop all of this stuff? So that would be assigned to the patent value. And then the third one is sort of more of the discounted cash flow method, where you figure out what the revenue stream out for a certain number of years based on that patented technology would be, and then you discount it back to the net present value, and then that would be the estimated value of that portfolio. We don't do this too much, but those models are certainly out there, and there are people who actually do this kind of professionally. Michelle, if you could switch to the next slide, please. We have a couple slides here that I want to go through quickly. One, I work with a lot of medical devices, so just kind of talking about that. You know, if you're dealing with a medical device, you need to describe your medical device with lots of detail. You want to describe literally, you know, every nook, every cranny, every screw, every bolt, every catheter shaft, every balloon on that device, how they're connected, how they move relative to one another, how they function, et cetera, et cetera. Again, that goes back to Leah's comment about enabling the invention in the patent application. Also in medical device patents, you want to try to claim the medical method, meaning what the surgeon does. And yes, it is correct. You would not generally sue your doctor for infringing your method claim, but where it's valuable, you can actually use those method claims to go after a competitor for contributory or inducing infringement. Take advantage of these patent term extensions for certain drugs and devices. File your provisionals as soon as you can to get those early dates. Be prudent in your selection of international jurisdictions. And then going back to Leah's earlier talk about assignments, make sure you have backup in case you can't get an assignment. Make sure you have an employee or consulting agreement that has a clause obligating those employees and consultants to assign the IP to the company. And then be ready for IP due diligence because you're going to go through it certainly in a medical device. I think next slide, I believe that's you, Leah. Yes.
So everything, you know, Doug has said about best practices for medtech really applies to a lot of different areas of patents. So a couple of things to think about in the chem and biotechnology space is in mechanical and electrical patents, you have figures and diagrams, and in software patents, you have flowcharts. We don't really have that in the chemical space. There's not a lot of pictures you can put forward. So instead, what we have are examples. And some of you in this space may have worked with patent attorneys where they've asked you to provide examples, laboratory examples of what you've done. And that can often be kind of really the meat of the patent for a chem or biotech case. And these should include data, laboratory experiments, comparisons, quantitative data if you have it, and comparative examples, right, to conventional compositions if that's possible. Data that supports surprising results or unexpected results can really illustrate the advantages of your invention and why it may be different. And you always want to, in chemical patents, go through and discuss other embodiments, potential substitute components, and various ranges for quantitative data. And you know, like Lynn mentioned earlier, you want to have claims that cover not only the composition you've created, but also products that maybe your commercial products that may contain this composition. You always have the option in chemical cases to add method of making or method of using claims as well. So I think we have a few practice tips from Lynn, and then we're at the end of our hour, so we'll wrap up.
Oh, next slide. Yeah, so really quickly to reiterate, file your provisionals and non-provisionals early. Do a lot of early harvesting sessions with your inventors. Like, you got to mine for those inventions that are ripe for patenting. Don't forget about design patents and trademarks and how they're different, but they do build your portfolio, your IP portfolio. When you're writing your applications, you got to think about the different types of claims that cover your invention. When it comes to EE and software, you want to do servers, what they perform, what happens on the client devices side, what happens in terms of just a method claim that's being done by a processor or like CRM claims. And finally, Alice, I'll run through Alice really quickly, but Alice, 101 rejections, you have to be mindful of your potential 101 rejections under Alice. There was a claim in 2010 that, case in 2010 that said that claims that are drawn that were implemented on a computer hardware, tangible computer hardware, was actually still found to be abstract because they were saying, so this was a case about electronic escrow services, and they were claiming that this is things that can be done in the human mind or by human activity and such. So to Alice proof your claims, you have to include practical applications of your invention as well as improvements over the prior art. Write that into your specification, explain it very thoroughly, and that will help us get us over that 101 line. Yeah, so I think that's about all I have for this. I'm going to pass back to Doug if we have time to go to the next slide.
Okay, let me just have 30 seconds. And Michelle, if you could go to go forward, go forward, go forward. All right, thank you. So I just want to mention very briefly the use of analytics in patent prosecution. You know, we are in the information age these days. There's tons and tons of data out there, and we have tools, and I think other people may have tools as well, but we have, you know, tools that allow us to scrape in that data off of the internet and find a lot of very interesting information. So here, you know, just an example where somebody asked us about the use of this drug paclitaxel. And in terms of patent filing, so we were able to, you know, we were able to generate this curve, and you can see there's a peak around the, what, 2016, 17, it's pretty small, but yeah, I think it's 2016, 2017 timeframe. So obviously we knew there was, you know, a lot of activity around then. So we were able to see where filings are occurring. And if, Michelle, you can go to the next slide. Not only can we see when the filings are, but again, this is very small. You probably can't read it, but we can identify who is actually doing all the filings. So at a very high level, we know what's going on, when it's going on, and who's doing it. And if we dig deeper, we can get a lot more information. And I'll just leave it at that, the use of analytic tools is definitely out there. So, you know, consider using these to be a more informed consumer, if you will. And that's it for us today. Lynn, do you want to just wrap things up?
Sure. I think we had a couple more slides down, Michelle. Yeah, so conclusions. Patents are important. Protect your inventions during fundraising or even in an exit. Consider all the different types of IP that we ran through today. They really all come together to make a good patent or an IP portfolio, not just patent. You create a comprehensive IP story that addresses patents, FTOs, patentability, ownership, and really monitor your portfolio to maximize value and manage those costs. Like, you need to prune it and take care of your patent pet. That's it.
Okay, well, good, thanks. We're actually at the top of the hour, so I think we should let our audience go. Sorry that we couldn't not get to all of your questions online. If you did type your question in the Q&A box, I believe we will get a report, and we will be able to circle back with you after the webinar with you know, a few further comments. Michelle, if you could just scan to the last, scroll back to the last, there you go. Our email addresses are on the screen. Feel free to contact us. We're happy to chat with you offline further. But I don't want to keep people. So again, thanks again, St. Louis. Great to see you. Great to be a part of the Startup Week. Good luck to everyone. And thanks to my colleagues, Lynn, Leah, Michelle, and Brianna for making this happen. Have a good day.
Thank you so much.